Good morning, friends. This presentation is regarding the differences between the registered owner and the ownership. Whether the registered owner will have all the privileges as an owner, this is what we are going to discuss in this presentation. And particularly with in recent Supreme Court judgment in one of the real estate case in Gujarat, the judgment created some confusion because the title says that registration is not final. Registration is not the complete ownership for anything. So somebody or many got confused whether the property registered on somebody's name is the final owner or not. But the reality is something different. Registration process is different and ownership is different. Each has its own privileges. Some of the details we'll be discussing in this presentation. Before we get into the details of the real estate or a property ownership, we have to understand there are certain laws out there. In fact, for the last several centuries, there are no specific laws with respect to the property transfers or property changes from one owner to other owner. Sometimes it may be only on a piece of paper that you transfer the property, or sometimes it is just as a verbal gift or verbal transformation, some exchange of money or a consideration. In fact, in British India, when they started making the laws, codification of the laws, one of the important law is the Transfer of Property Act 1882, which is based on the Indian Contract Act 1872. In fact, property transfer is one of the contracts. Contract is nothing but an agreement between two or more parties. That agreement is legally enforceable, subjected to certain conditions. In the Transfer of Property Act, it clearly says what type of a transfer can be transferred to a property can be transferred and what are the issues arised or privileges of the ownership. All those things, this particular TPA Act, they give the details. Subsequent to these two acts, the Registration Act, which formalize the ownership or formalize the registration. After these three acts in the British India period, post-independence, one important act related to the property transfer or a property related is the Real Estate Resolution and Development Act, popularly known as the RERA Act 2016. These are the acts prevailing in India today for any property related issues, whether it is a registered or a ownership and all that. So now we should know some of the rights. Any property is not an absolute right. The ownership of any property in the country is not an absolute right. But when the constitution is made, the right to property was a fundamental right. Subsequently, the right to property from the fundamental right has been diluted with respect to certain agricultural rights with the changes in the Article 31. From 1977 onwards, with the 44th Amendment to the Constitution, the right to property has become only a constitutional right and it is not a fundamental right. What does that mean? Whether somebody is having a property and its ownership, can it be seized just like that if it is not a fundamental right? Yes, but only by the government and authority with certain conditions and restrictions. But however, the constitutional right clearly says that you have a right. But all the constitutional rights are enforced based on certain legislation. So now coming back to the property is usually either the succession or inheritance or by ownership or by possession or purchase. So with respect to the succession and inheritance, The property is transferred from one generation to other generation or one person to other person within the family. That is what exactly succession or inheritance. These laws are different from the different religions. Like a Muslim personal has a different, and Hindu Succession Act 1956 has some different rules and regulations. However, all the properties, once somebody is possessing, there are certain privileges and rights with the restrictions. There is also called an adverse possession. This law says 12-year land law. What it means is a person who continuously occupies any private land, not the government land, private land for 12 years without any claimant coming therein, then the person becomes a legible owner of that particular land or a particular property. Of course, this issue has raised many concerns. How a person, for example, somebody has gone abroad and his house or his land is just kept vacant, and somebody knows that he is not going to come for next 10-15 years. Can I go and occupy that and say it is mine? So this is also some kind of a injustice, the person who is unable to monitor their own property. However, the law says that if you are not aware of your rights, you will be losing your rights. That is what the law says. But this 12-year land rule ultimately has been challenged, and in the Supreme Court it made an amendment. Yes, somebody can use that particular possessed property if there is no claimant for last 12 years. However, that has to be registered, and before registration, a notification is to be issued to concern, or an open notification if any claimants are there or not on that property. Then only the registration can be done. That is the reason we have the 12-year encumbrance certificate as a common rule for any property registration. But this encumbrance certificate, actually it has to be 30 years if you wanted to make clear, or if you wanted to make sure that there is no litigations for the future. So there are so many disputes will be there, and joint ownership, everybody whose name 2 or 3 or more, the property has to be registered on their name with a proper. Now let us understand the difference between the ownership and the registration. Ownership has certain privileges. In fact, ownership is kind of a full right ownership. A property under whose possession is there, if he is the owner, he can use that property, he can utilize in any way, he can transfer, he can dispose, he can destruct, whatever the way he wants, he can do. He can sell, lease, mortgage, but there are certain legal restrictions. Like I said, no property is absolute ownership. If government decides to utilize anybody's private property, government through some rules and regulations and compensation, it can be taken out from that particular person, and it can be used for the public interest purpose only, not for any other purpose. A government cannot seize the property of somebody and give it to somebody else. No. The property, government who try to take the property of somebody, it can be only utilized for the public interest, public purpose. So let us not get into the details of what is the public interest and all, but generally, for example, for the railways, bridges, these are all in the public interest. So if my land obstruct the railway line in between, then government forcefully they can take my land, but they have to pay the market rate plus something extra also. I should not be the total loser because somebody is taking my land for a public purpose. So there are certain rules and regulations. Now, what is the registered user? Whether if I get a property registered on my name, I am the final authority and final owner? No. So the registration usually talks about if he is a registered user who is not an owner, if that's what it says, then he is only like a tenant registration will be there, lease registration will be there. They are for the temporary possession. Similarly, when I mortgage my property to a bank or somebody for some any financial registration, it is also registered based on certain agreements. But the bank is not an absolute owner because it is registered on the bank's name. It is a limited conditional registration. Like a license to use the property, lease for 10 years, 20 years, 50 years or 98 years or 99 years. There are certain restrictions. The registered user is only he can use the property based on terms and conditions, he will not be the final owner. This exactly is the confusion based on the Supreme Court verdict. However, if I need to own a particular property, I have to take care of certain things. How and what are the things I should take? First, I should understand that I have a absolute rights subjected to the legal rentals if I am a owner. And the legal protection I should ensure only through the register or registration of my property. Even if it is inherited from generations together, when I try to know or when I find that it is not yet registered, then immediately I have to register. There may be some corner somewhere in some generation that the property is given to somebody, but it is not properly documented. So the registration enables the owner to utilize his legal protection. And whenever the property is transferred, registration is a mandatory. Before you try to buy a property and wanted to own a property, one has to take care of extra steps. Title search, whether the title means the ownership name in the registered record. That is what the title. So I have to search the title. If there is no record is available, then I have to inquire whether this property has been given to somebody or who is the owner, who is selling this property. All those things I need to take. And ultimately, the registration is a final step to ensure that property is owned by me on my name and my title. And registration is possible only based on certain stamp duty payment. So that will ensure that now the government and the law is in your favor. It will protect because the government has registered the property on your name after taking certain fees, that is a stamp duty. So you have the legal protection here. And one of the important things to see if the property is having any problem or any litigation, encumbrance certificate. Usually they say the 12 years because that adverse rule applicable for the 12 years. But you have to ensure that the 30-year encumbrance certificate has to be there. If it is any land, 30 years you can get it. If it is any building, then the building age may not be 30 years, it may be only 5 years or 10 years or 15 years. You are buying that. But the land on which the building is there, it will be more than 30 years because building is a continuous. So the land is a continuous. So you have to take the 30 years EC for the land and whatever the period the building is existing, that period subjected to minimum 12 and maximum 30 years. You have to take it. All these things, it will be available with the government register. We call as a record of a registration. In the record of registration, all the details will be there. Through encumbrance certificate, you will get the information. And property card is nothing but the encumbrance certification. When you go to the registration sub-registrar office, you have to ask for the EC. Term of the EC, in some states called as a property card also. There is no such confusion. And if any dispute is there, particularly if it is a building you are buying from some apartment, gated community or somebody, which is under a RERA control, that is your registration body, regulation and registration, you have to file a complaint, you have to inquire with the RERA, is there any legal issues are there? And you can certainly use the legal authority to verify these things like a lawyer and advocate. And all the details, once registered, they are on the government portals. This portal will give you all information regarding what is the registration period, what is the registration stamp payment duty, and who are all the earlier owners. All those information will be there in the portal. And with respect to the adverse possession protection, you have to make sure that you will not give away your property on rent or a lease for more than 11 years. If it is more than 11 years, then there should be a break, and you should, after that again, you have to do a separate registration. And all that is to be registered. All the agreement has to be registered, and the payment of the rent or whatever the consideration, it has to be legal through online or with a proper due receipt, so that it cannot be misused by the person who is under the adverse possession. And of course, one of the best idea is also to insure your property in safe, so that insurance also will be your legal protection. And there are certain challenges that you should face during this particular thing, registration ownership. So make sure that you buy only the RERA registered projects, not non-RERA. And any title disputes, encumbrances, you should have a clear legal clearance. You should obtain a legal clearance, then only you can go ahead. And if there is a giant development rights are there undisclosed, then you have to ensure that you have to get the information from the relevant builders and check all the documents and take a legal clearance. And the occupancy certificate is very, very important. Most of the, even although it made a mandatory for last few decades, not many people, particularly for the independent owners, they will not bother to take occupancy certificate. At any point of time, their property is under the legal risk. And with respect to the apartments, gated communities, under construction, normally they will not give any occupancy. And many people buy and even occupy under construction. And once it is registered on somebody's name, the original owner will not bother to take any occupancy certificate. And when you, after the construction is completed, when you approach them, there will be a lot of penalties why you have not taken at the time of a occupancy. So no objection certificate and occupancy certificates are important to avoid any fraud or any kind of a litigation. Some of the legal consideration, like I said, is a RERA registration, 30 years minimum title chain, that is a EC from the registrar, and all approved layouts also you have to check up. Approved layouts are available in the Panchayati layout or a sub-registration office, and you have to check up whether your plot or your area is under the approved layout or is there any litigation. And you have to follow the building laws also. So this is a general checklist. RERA registration is essential. Demand for the plan, you have to get all the approvals, including environmental NOCs and sale deed and mutation records. Builders history for the RERA portal, and particularly you should prefer the housing societies or gated communities where the rules are very much complied with. And always you have to take a legal vetting. A well versed lawyer can give you the legal vetting for your sale agreement. Sale agreement is one, although it is not essential, but always it is preferred that you have to have a sale agreement, that too registered. Unregistered sale agreement is not valid. And don't take any letter of allotment, because particularly in some of the societies and all that, they give a letter of allotment as a final ownership, and because the entire property is already registered. So you should not take, you have to take the complete registration, because some people try to avoid the stamp duty, they may take a letter of allotment as a final, which is not legally safe for the owner. So these are some of the main recommendations. Like once again I am saying, the RERA registration you have to see, title certificate from the property qualified property lawyer, legal income certificate for 30 years, and particularly cash transactions. Beyond certain limits, there should not be any cash transaction, because if you buy, although it is registered on your name, so there may be some issues with some of the undecided or unknown claimant, saying that he is not purchased. There is no evidence of the property. So evidence of payment of the property fee or property, whatever the price. So these are some of the issues will come. So always make the payment through a legal bonds or a legal check or bank transfer. Some of the available tools for that. Okay. And don't take any under construction resale unit without NOC. Even if it is under construction, the legal agreement should be there, registered, and after completion of the property, you have to take the occupancy certificate as well as the entire registration through sub-registrar. So friends, these are some of the important points with respect to the registration, user and ownership. I hope I was able to clear some of the doubts, and if you need any further clarification, please you can contact me. Thank you very much. Good day.